Well, I was going through the PCR's expert evidence to show you how they describe adverse selection risk. I've gone through the Evans experts and now to the O'Higgins expert, Mr. Breeden. And I'd ask you then to take up first the first volume of key documents, hard copy volume of key documents, tab 22.
Yeah.
Breeden 1. Page 1626. This is to the same effect as Professor Ryan. We're looking at paragraph 4.3 and the lower half of 4.3. I just want to show you the sentence that begins additionally in a dealer market. And that's page 1626 of the bundle, a hard copy. Bottom half of paragraph 4.3, the sentence begins, additionally, in a dealer market, if a dealer knows that informed traders are present in the market, they will tend to widen their bid-ask spreads. So the money they lose to the informed traders is compensated by the larger revenue. And going over the page, please, to 1628, you'll see two references at the top of that page to order flow. I mentioned this earlier in my submissions. At the last sentence of paragraph 4.6, immediately above paragraph 4.7, knowledge of the order flow is a key source of information and competitive advantage. Next paragraph, about 4 lines down, dealers set prices based on order flow, and therefore knowledge of recent and prospective order flow confers a competitive advantage. And you have my point about why winning volume is a way of getting order flow. Still in Breeden 1, please, to a point that was taken up by my Lord the Chancellor, page 1630. When you were looking at this, my learned friends, you noted the US Ashton proceedings.
Yeah.
And queried whether there was anything here that suggested market-wide harm. And in my submission, there's nothing here to suggest market-wide harm. The harm that's referred to in the Ashton Prohibition Notice, we see at paragraph 4.13 on page 1630. It notes that Mr. Ashton held senior positions at Barclays, that's obviously a respondent bank. But halfway down the paragraph, there's a reference to trading practices detrimental to clients, to his clients. And then at the bottom, Ashton, the trader, received a financial gain or benefit, and Barclays, the respondent bank, suffered financial loss or other damage. So that was as far as the finding went, at least the one quoted by Professor Breeden. So, stepping back, my lords, and reflecting on what the PCR's experts tell us about the adverse selection risk theory, and taking it in stages. According to this theory, because the respondent banks shared information on outstanding customer orders and current and planned trading activities, they could inflict, to quote the experts, small but persistent losses on all non-respondent banks in the interdealer market. The theory is that the non-respondent banks detect those losses and isolate them from all the other losses and lower profits in the ordinary run of business. And it even is suggested that the non-respondent banks have to attribute these losses to the fact that there are better informed opponents in the market, information asymmetry. And then the theory goes, the non-respondent banks will respond by changing their pricing strategy, respond to these particular losses by widening their spreads in the customer-facing segment. And you have the major questions that this begs. First, how could the respondent banks use their shared information to cause even small but persistent losses to the non-respondent banks? And I've made the point that their market share varied widely, in times in the 20s or 30%, with trillions of dollars of trade and factors determining prices changing by the second, hundreds of factors determining prices changing by the second. How can that kind of exchange cause material loss across the market? Repeating the exchange I had with my Lord Justice Snowden before lunch.
Yeah.
And that brings us to sterling lads. because it was suggested that Sterling Lads may have some insights of value to the court. And my Lord Justice Green raised the question of the admissibility of the Sterling Lads decision. This, for whatever reason, hasn't come up, at least not to my knowledge, previously. And so we asked ourselves, is the Sterling Lads decision even admissible? Because it's a post-Brexit decision. And we have a note, a one-pager to give you on the admissibility of the Sterling Lads decision. But the punchline is, it's not admissible.
It's what?
It's not admissible, my lord. It's not. It's subject to the post-Brexit regime, and according at least to the tribunal, the Competition Appeal Tribunal, a rule which is the equal of the rule in Hollington and Hewthorne applies to it. So I'm going to give you the.
Couldn't you make that point good?
I'm going to give you the note.
In a civil court.
Yeah, it may be hearsay. I seem to remember there's a case going back almost 30 years which held that they were hearsay, but then wasn't that abolished in about 30 years ago, so that they're admissible, but it's all a question of weight.
Well,
no, you're talking about findings of fact.
I'm talking about
findings of fact made by one tribunal and not evidence of the fact in front of another tribunal.
I'm grateful to my lord because obviously, to the extent that it records evidence, we can't object to that. That's admissible. Of
Well,
course.
that's the point, though, isn't it? Because it's relied on for the fact that it shows a wider, the wider scope of the operation of the relevant cartels.
To the extent that there is reference to evidence in that Sterling Lads decision, exchanges and so forth, that may well be admissible. My point is about, and I think this is the point that my Lord Justice Green was making. The Commission goes on to make findings of fact in the Sterling Lads decision.
I agree. It's an interesting point about admissibility. I don't think it goes so far as to say it binds anybody, but what you've got is on a body of evidence which is describing a cartel which is at least comparable to that which is an issue in this case. It's going more or less the same time, not the same parties as Credit Suisse, but you're looking at a model. And the Commission find on the evidence two things. One, systemically, it's capable of having harmful effects on competition, and competition is treated as a benefit to the cartelist and a disbenefit to counterparties. And then they go beyond that, not just, if you like, the systemic effect, but they say as a matter of likelihood it would have had this effect. So it's hypothetical in that sense, but it's based on evidence. So if one's saying, does it corroborate the approach of the class representatives in the present case, it's indicative. It's not binding.
My lord, I'm not this is a point of principle, so I'm afraid I have to address you on it because it's not about
principle. It's a nice point of law. We'll be very relieved.
Finally.
One point of law in the case.
Yeah.
It's all about the admissibility of Sterling Lads.
Well, but you can see why it's a very important question for my clients because I'm not suggesting the question is not about.
That's right. We're getting very excited. That's what we're really saying.
The question is not that it's. The question is not.
Some of us are.
The question is not about whether it's binding. We are saying it's not admissible in respect to the findings of fact my lord refers to. My lord is being referred to findings of fact.
It's in a decision. It's in the public domain. What do you mean by inadmissible?
You can't rely on the findings of fact as I think is it Hollington Hewthorne says, but evidence of the truth of their.
They couldn't rely on. The point is, they couldn't rely on it as the only evidence to support a case at trial.
They can't. My lord,
Could they plead this? They can seek to prove it by other means at trial. Why wouldn't they be able to show that?
I need to show you the note, and I'll take you through the materials. This won't take long, and I'm keeping good time in terms of my time with my submissions. Can you give the note, please? I'm going to give you a one-pager, and the supporting the amendments to the Act, and Qualcomm, the judgment in the tribunal.
Oh yeah, Qualcomm.
This is not the Qualcomm in your authorities bundle. It's
the other Qualcomm.
It's the other Qualcomm.
There's plenty of them.
So first, the note. And my own friends have this.
Yes, okay. Thank you.
Sorry, I was sent this morning.
Yeah.
Okay. So the first point in the paragraph 1 is a reference to the new section 60A of the Competition Act. The old section 60 of the Competition Act, and I'll take you to it, require the tribunal in resolving cases like this to have regard to decisions of the Commission. This is the new section 60A. The tribunal must have regard to any relevant decisions or statements, have regard to any relevant decisions or statements of the Commission, but only those made before the IP completion day and not.
What does it say about the position after the IP? It doesn't say you must.
Well, and that's why I'll take you. So thank you. I'll take you now to Qualcomm. So that deals with what happens under the Act. And now Qualcomm, which you should have, this judgment of the tribunal of Ms. Justice Bacon, and you see what kind of case it was. Paragraph 2. It was a collective proceeding brought by which the applicant had relied on findings made in foreign decisions. And a very friend, in fact, Mr. Joel for Qualcomm brought a strikeout application on the basis of the rule in Hollington and Hewthorne. And the pleadings are referred to, and we have the analysis of the court in paragraph 13 on page 6 of the judgment. And the modern interpretation of the rule in Hollington and Hewthorne is that, absent the operation of estoppel, factual findings in civil cases in England and Wales are inadmissible in subsequent proceedings. It doesn't extend to criminal convictions. There's a reference to the judgments of the Court of Appeal in Rogers and Hoyle. The learned judge referred in paragraph 14 to exceptions to the rule, and she noted that under sections 47A and 58A, final decisions of the Commission in competition cases were admissible before the courts in this tribunal and were binding in follow-on actions and could otherwise be considered persuasive, and that's the Korean judgment of the House of Lords to which reference was made yesterday. Qualcomm argued for Hollington and Hewthorne direct applicability, and the learned judge rejected that because the tribunal was not bound by the High Court rules of evidence. But she says at paragraph 22 on page 9, having arrived at the position that we are not bound by the rule in Hollington and Hewthorne because the tribunal has different rules of evidence, the question then arises as to whether this tribunal should nevertheless adopt the same principle. And she said, we are of the view that the trial of these collective proceedings, it would not be appropriate to attach any weight to the findings reached by other courts, tribunals, or regulators obviously including the Commission. The principal reason is the one given by Lord Justice Christopher Clark and Rogers and Hoyle, being that it is for this tribunal to assess the evidence and make primary findings of fact, relying upon the evaluative judgments of other decision makers necessarily circumvents that role. To place weight on their findings, any weight, however distinguished or authoritative, risks the decision being made, at least in part, on evidence which is not before the tribunal. Over the page, paragraph 28, the point we've just been discussing, there's no objection to references to the decisions of foreign courts to identify the evidence which was before those decision makers. We distinguish that from findings of fact. What it objects to is a suggestion that the tribunal can give any weight to the evaluative findings of those decision makers as part of the process of reaching its own decision on the evidence before it. And so paragraph 33, for those reasons, although Hollington isn't binding on the tribunal, it's appropriate to adopt the same principle, the same reason in these proceedings, and the relevant reliance on findings in the reply, the pleading of the applicant should be struck out.
I'm just looking at the pleading itself, which was seeking to rely upon decisions of the South Korean Fair Trade Commission and the Seoul High Court and the Taiwanese Fair Trade Commission as what they described as in paragraph 42, the combined evidential record which justifies the obtaining of disclosure. This is paragraph 6, and then paragraph 42, the pleading.
Yes.
So do you say that the decision is not even indicative of the approach which the CAT might in due course take. It can't even be. So when they say under the horizontal guidelines, as in response to Credit Suisse's submission, that these sorts of arrangements are to be treated as systemically likely to affect competition, that's irrelevant.
Yes, because that's
So they can't cite the guidelines themselves.
no, they can cite the guidelines, and they can, and to the extent that evidence is put before them which supported the Commission's conclusion. But it's important distinction, and there are really important points of fairness underlying it. It's not a cheese point of evidence. As Justice Bacon found, this is rooted in principles of fairness. It is not admissible at all. The findings made by the Commission, however ostensibly relevant and distinguished, cannot be given any weight in the assessment that the tribunal will undertake.
On anything at all, on no matter arising.
That is what inadmissible means, my lord.
Well, it can
So-
be inadmissible for one purpose. and another.
Forgive me, I mean admissible to the extent, sorry, I thought we were discussing
Inadmissible in evidence.
inadmissible in evidence. So if to the extent that weight is supposed to be given on these evaluative findings as part of the process of the tribunal reaching its own decision, that isn't permitted. So
As an approach then to construction of Article 101 as a matter of law and object?
no, that's why the Sterling Lads decisions in the authorities bundle. Of course, the Commission offers a view on what Article 101 requires and the consequences of a breach of Article 101. And as an authority, it can be cited, of course, for propositions of law. The evidence referred to can be relied on, but what it cannot be relied on in any way is for the purposes of giving weight to its evaluative findings as part of the process of the tribunal, in this case, reaching its own decision on the evidence before it.
And was the judgment of the CAT in paragraph 33, the judgment was that Hollington and Hewthorne is not binding,
Yes.
and they say it's not appropriate to adopt the same principle in these proceedings. Is it fact specific?
My submission, my lord, the reasons that the tribunal gives for adopting the same approach in the tribunal apply generally. Paragraph 23 of the tribunal's judgment applies the principle of Hollington and Hewthorne for reasons which we say are of general application. I appreciate it refers to these collective proceedings, but the reason it gives is the very same basic principle which underlies the rule of Hollington and Hewthorne in the High Court. There's nothing fact-specific about it. Now, that leaves the question of, what about Crean?
So are we at some point going to look at the decision in Sterling Lads? So you can tell us, as it were, which bits we can't look at?
Well, I'm going
Or
to...
are you just going to say,
Can't look at it all.
we can't look at it?
No, I'm going to, for the avoidance of doubt, I will take you to the part of Sterling Lads that, prejudice to what I've just told you about it being completely inadmissible. I will take you to one paragraph, which I say, upon which no weight should be placed at all.
Yeah, it just would be useful to be able to have you identify which bits we can't place any weight on and therefore are inadmissible. You say that might otherwise be relied upon against you, since
that's the issue. I understand. Yeah. But on this important point of principle, I've given you on Hewthorne. You have the old section 60 in the pack which I've given you, and the new section 60A, and the transitional provisions, which, as we say in our note, would apply in proceedings against an addressee of that decision, but don't apply here. So on Sterling Lads' decision itself,
where do you want us to
that
put these various documents?
doesn't have a home, I'm afraid.
I'm just going to stick it.
Is my Lord the Chancellor? Okay, do you?
Well, I'm having a nosebleed as a result of having a cold, and I think I'll be all right. But
I'm doing okay for time. If we need to rise for a few minutes for my Lord to...
What he's really saying, it's not your submission.
it's not your submissions.
I was hoping that wasn't... Probably.
It might be sensible if we rose for just a couple of minutes whilst I just try and get some more handkerchiefs or something.
All right.
seen advocates collapse. I've seen the judge react to that submissions.
Sorry about that.
I've seen Christopher Ryder nearly fainted. Seeing all conditions.
Yeah, it's very warm, isn't it?
Yeah.
This is very warm.
Yeah, it's unlikely you'll be replying today, but if you want to go first, or should I go
I'm very happy to take this point back.
Okay.
Because
If we don't get one today, maybe we'll have to put it.
yeah.
Oh, God.
It's boiling.
Just me going through the menopause.
So it's better.
I'm not sure that's okay. It's difficult. Yeah. And it's the point that I sort of that I think this one's position is the one extreme or the other. It's not binary. I don't know if I'm ready back in terms of the carriage dogs. I think you've got extra. We've got a list, so we're going to hand out the train coordinator of their clerks, inserting that. So I think the approach we're taking is a kind of a reading list of extracts, but with the big docs going in, so kind of full statements for them to put in the key docs. So maybe that overlaps a bit. I can explain that.
Alright.
Printing them out.
Hopefully you'll be all right now. It was crossed. Sorry about that.
Not at all. We're going to the Sterling Lads decision, and the passages which we say do contain the kinds of evaluative findings which are not admissible. And the first is and Sterling Lads is in the 6th volume of Authorities behind tab
60.
and it's page 1752.
1752?
Page 1752.
Yeah.
Recital 171. In fact, these are the very recitals to which we were directed by my Lord Justice Green, precisely because they contain findings which, absent the admissibility issue, might appear to be useful. But recital 171.
Sorry, I've now failed to get my 1752 of
1752 of the 6th Authorities bundle.
It's inadmissible in evidence. That's your position. That's what Mrs. Justice Bacon has decided. But does it follow from that that they can't even rely upon it, as it were, as a support for the expert case they seek to put forward before the tribunal? It may be that they can't rely on it as evidence or as establishing facts that they want to establish, but they can surely rely upon the fact that it has decided it's reached a conclusion about the economic effect of this sort of cartel.
To the extent that the PCR's experts want to rely on it, they can.
If you look at it in terms of forget that it's the European Commission for the moment, assume it's a judgment of the European Court of Justice or something like that kind. You would cite that as not necessarily binding authority, even post-Brexit. You might cite it as establishing a principle that's applicable in Europe, which is then argued should be applicable here.
Which is why I respectfully agree, for the purposes of a legal submission, for the purpose of saying this is how the Commission applied Article 1011, this is what the Commission regarded as infringing behaviour. For a point of law, of course, they can rely on this Commission decision. The point I'm making, though, is that in the paragraphs I'm about to take you to, they're not making legal points. They're making evaluative findings of fact, and that's what's inadmissible in its entirety. Now, the PCR's experts can refer to it and cite it, but when the tribunal comes to make up its own mind, it can't give any weight to these evaluative findings by the Commission in Sterling Lads.
Well, it can't in reaching its determination at trial, but surely at this stage, in terms of satisfying itself that the expert case, the theory of harm that's being advanced is an arguable theory of harm, sufficiently arguable for certification purposes. Are you really saying that they couldn't have had, that if Sterling Lads had been decided earlier in 2021 before the hearing was concluded, that the CAT couldn't have looked at it at all?
Well, yes, because for the purposes of evaluative findings of fact, of course they can look at it for legal points and for all the evidence upon which it relies. But this point about Holland and Newthorne is a very important point. It doesn't apply only to trials. In this context, it's absolutely on point. It's saying that these evaluative findings are inadmissible as a rule of evidence in the tribunal, and the basis for that is not a capricious accident of history. There's a fairness issue, an important fairness issue, which underlies the rule of evidence, which underlies the tribunal's decision in Qualcomm. And the difference with Brexit, of course, is that prior to Brexit, Commission decisions had a particular status that had to be recognised in statute in order to make an exception to the rule of Holland and Newthorne, which is what we had in the old Section 60 and under the duty of sincere cooperation in the treaty.
Well, I understand your submission, but I'm saying the context of what the CAT had to decide in the context of your submissions this morning, in effect, that this is, this is all pie in the sky. I won't use the word rubbish anymore, but it's all pie in the sky. To suggest that the CAT couldn't have had regard to sterling lies if it had been decided previously, as supporting the viability of the theory of harm that's advanced, not as evidence of anything, but just as supporting its viability. I find a very extreme submission. You may be right, but I
The
need
problem
a
is if it's not, how does it support it unless it is supporting it as an
And you
evaluative
say in
finding
terms
by
of
the Commission?
fairness, Mr. Kennedy, but it might be said against you, well, shutting it out completely and then saying, well, this theory of harm is so hopeless they could never pass muster before the CAT, and therefore either they should be struck out or they should only be certified on an opt-in basis because their case is so impossibly weak. Whilst knowing that this is out there, I find that very, in terms of fairness, I think that's pretty extreme submission with respect.
Can I just make sure that there's not a cross purposes going on here, just to some extent, clarified in my own mind. There are two things the CAT, was doing or did. One was to certify on the basis that there was a workable methodology to demonstrate loss. And on that theory of loss, that there's a workable methodology, why couldn't an expert say, well, a similar theory of loss appears to have been accepted in this case, that case, another case. It's not relying on the evaluative findings of fact as such, it's just saying this is appears to be the same theory that we want to advance in this case. It seems to have worked in another one, in front of a tribunal which is not unversed in the area. Different point, which is when you're evaluating what is the strength of the case that would ultimately be tried, you may say, I think you are saying, in evaluating the strength of this case that would ultimately be tried on the facts, you can't rely upon evaluative findings of fact in another decision. Is that a distinction that's there to be drawn? Have I understood it correctly?
My Lord, I think that distinction is there, but I make the point that it's admissible for both purposes. The second of the two, my Lord, is described for sure, we say, it would be inadmissible for the reasons I've described. But even for the first, it would be perfectly open to the tribunal to say, at certification, we note that in the Commission decision, extensive expert evidence was produced about adverse selection risk, and no doubt the experts could refer to that. But then to go on to say, and we rely on the fact that the Commission, in evaluating that evidence, approved it or adopted it, that is the kind of evaluative finding.
Yes, but what it's saying is, a body versed in the field has not thrown that out as a piece of nonsense methodology. In fact, they seem to have accepted it. So if you're judging whether the methodology that's proposed is a runner, which is my version of the test that you're applying, I can't remember what it is, supposedly.
Plausible.
Plausible, thanks. That somebody else who knows what they're doing in the field appears to have accepted it in a different, could be a completely different case, in fact. Why wouldn't that be capable of being relied upon by the CAT on that question of whether this is a certifiable, plausible methodology? Different from the proposition about whether in this case, on these facts at trial, you can rely upon an evaluative finding as a matter of fact, which is what I call your pure Hawthorne, whatever it's called. Competiton Hawthorne, thank you.
So I make 2 points. The first is that in that scenario where the tribunal is saying another body has followed this, has adopted this evidence and followed it, that, I respectfully submit, is giving weight, may not be much weight, but it's giving some weight to what is ultimately the evaluative finding of a foreign regulator, because in order to... not throw it out in order to adopt it, that necessarily is an evaluative finding by the Commission. And the second reason is
But
fairness.
it's not a valid finding of
No.
fact as such.
No.
So far as my lord's two categories are concerned, you say they're both inadmissible, but I mean, I follow the point about the second one. If you look at what Mrs. Justice Bacon says in paragraph 28 of her judgment, that's really dealing with the second one. It's not dealing with the first point at all. It's not dealing with whether an expert can put forward, whether it can be said that the expert case it's a viable case to go to trial because it's amongst other things a similar conclusion or a similar approach has been adopted by the European Commission.
The problem is that ultimately, when you're assessing strength, you're asking yourselves, what will be of weight before the tribunal at the final trial? The question is...
Well, at the final trial, on this hypothesis, the appellants will have to produce evidence to support their case along the lines of what was before the Commission in Sterling Lads. They won't be able to just rely upon Sterling Lads.
So they can rely on it, it's admissible for this purpose, but once we have a trial, it can't be relied upon in any way. The rule...
It's not relying
rule
upon it.
described-
It's not relying upon it, as she said. It's not giving any weight to the evaluative findings as part of the process of reaching its own decision on the evidence.
But the decision about the strength of the case is a decision. It's an interlocutory decision, but it's a decision that has to be taken. It's an assessment that has to be made on the evidence for the purpose of certification. And the judgment, in my submission, is clear.
Anyway,
that
I think
it says no
we-
weight at all because of the inadmissibility point.
We've got the point. You were going to show us paragraph 171. We've interrupted you, for which we
Not at all.
apologise.
Sorry, one second, Mike.
Yeah, sure.
It was the second point I was going to make, which is a fairness point. My Lord Chancellor put again a very robust common sense fairness point to me. We would put one back to you, which is that the reason for this rule in this context is grounded in fairness is because the Credit Suisse have rights of appeal. They have rights of appeal against this decision. There's a mass of evidence here, and it's not before us or you. And Credit Suisse have a right to appeal, and they have appealed.
Sure.
And that is the vice. It's superficially attractive. It's tempting to rely on these evaluative findings and pray them in aid, but it's treacherous because this evidence isn't before you, and we're not able to test it or appeal the findings themselves.
Okay.
So it's one last go. So we've got three decisions, two of which are settlement decisions, and then we've got Sterling Lads. We assume that the Commission adopted the same theoretical approach in all three cases. Can we therefore assume that this 400-odd paragraph decision is reflective of the approach they would have taken had it not been a settlement decision and it had been a full decision in the present cases?
It's certainly open to them to say the settlement decisions are usually very short, and that contested decisions are longer. This is a contested decision and it's longer. I think we could probably say that, although again it's slippery. It's a slippery slope. But I think it'd be going up quite far for me to say they can't even point to the weight or the thickness of the decision. And they can make the point that on disclosure, much more information will emerge than would be reflected in the settlement decision itself. I think those are all perfectly fair submissions that could be made.
Mm. Yeah.
I'm asked again to make this point that in addition to the lack of a right of appeal against this decision, to the fairness point, we settled with the Commission on a different decision on different terms. We didn't sign up to this decision in any way. It doesn't relate to anything in which we had a role vis-a-vis the Commission. And so it's very treacherous, as I say, to rely on it in any way against us. But I accept that they can make the point that the settlement decisions in our case are necessarily short and contested decisions are generally longer.
And you were just going to distinguish courage and Korean. I mean, we know the case. What's the basic point?
Well,
That was a private. It wasn't a follow-on standard. It doesn't apply.
In my submission, the reason why it's difficult to see actually in Korean ultimately why the Commission decision was treated as evidence in that case. But in my that may just be because I read it very quickly again this morning, but the reason I submit is because at the time, the United Kingdom courts were bound by the duty of sincere cooperation under what was then, I think, Article 10 EC, not to thwart and to act consistently with decisions of the European Commission, among other things. And that duty disappeared after the implementation date, the implementation period, completion date expired.
But the House of Lords held that it wasn't binding.
I'm sorry?
The House of Lords held that it wasn't binding.
It's different, my lord. The House of Lords said it wasn't binding. We're not discussing bindingness. It's just, is it admissible? Now, in Korean, the court said it is admissible. It can be used as evidence, maybe even strong evidence, because it's coming from the Commission. That is an exception to the rule of
So
Hawthorne.
it wasn't about admissibility.
No, and the point is, how did they get around the rule of Hodgson and Hawthorne? It wasn't binding. It was either Section 60 or the duty of sincere cooperation. And the duty of sincere cooperation, sorry? Forgive me, Section 60 wasn't in existence, so it must be the duty of sincere cooperation. Then the paragraphs themselves that we say contain these evaluative findings in Sterling Lads are paragraph 171 on page 1752. And this, having gone through the evidence, the Commission says, by way of findings, the disclosure information removed uncertainties. My point is that all of these sentences contain evaluative findings by the Commission. The exchanges increased the level of transparency for chat room members. The Commission found that the information exchanges were taken into account by the participating traders. And then the Commission found that it resulted in an asymmetry of information between the Sterling Lads chat room participating traders and the non-participating traders. The Commission then found, evaluatively, that it provided the former with a competitive advantage. And, this is, we say clearly the finding based on evaluation of evidence, it increased the likelihood that those participating traders would make a profit from it. Now, pausing there, even if I'm wrong about everything I've said, that is a reference to increasing the likelihood of profit by reference to those traders in terms of their trading with non-participating traders. It doesn't deal with wider harm, it doesn't deal with how much likelihood or the magnitude of any harm. But that's by the by in my submission. And then the next series of evaluative findings are the ones referred to by my Lord Justice Green, which begin, I think, on page, forgive me, page 1840. Under the heading Application to this case at the bottom of the page, from paragraph 393.
Yeah.
And here the Commission, having considered all the evidence, makes a series of findings where it applies the legal test to the evidence it's considered. And from 394 all the way to paragraph 400 and 401 to its conclusion, the Commission is making a series of findings. And to my eye, every paragraph contains evaluative findings, right the way through to 401.
Yeah.
But we are not asked, in fact, sorry, the CAT will not ultimately be asked to make the same evaluative findings. I understand the rule in Poynton and Hawthorne is very clear that if the same issue arises, the same factual question arises, Judge B can't short-circuit the process of hearing evidence and deciding it for himself by saying, well, Judge A has in another case decided exactly the same factual question. The CAT is not going to be deciding exactly the same factual question as is being addressed in these paragraphs. What these paragraphs show is that a tribunal has, in a different case, on a different set of facts, found similar effects, found certain effects caused by similar conduct. Why is that not something that this CAT could have taken into account if it had this in front of it, as both demonstrating that the methodology is plausible and that on the facts of this case, a CAT might ultimately reach the same conclusion? In other words, when trying to assess strength of the case, which will ultimately be decided by the CAT in this case, why can't it look at the evaluative findings? Because it's never going to be asked to decide the same question that the European Commission was deciding in Sterling Lads. And that's the vice that Hollington and Newthorne is supposed to be addressing. It's the short circuit by Judge B of the process that he should go through, or she should go through, because some other judge has done it before. And that's not the same thing that's going on here, is it?
In my submission, the rule, I was quite right respectfully that is the main vice which the rule is designed to prevent, but the rule goes further than that. And the starting point is that the tribunal in certification has to make a decision. It's a decision at the certification stage, but it's definitely a decision on the evidence. And the question is, in making that decision about the strength of the case for opt-in, opt-out, can it give any weight to the evaluative findings of the Commission? And inadmissibility goes that far. It may not, under the rule, give any weight to the evaluative findings of the decision makers in a different case. And even the rule is not limited to situations where the decision taker in England is asked to address the very same question which the foreign regulator addressed. The rule is broader than that. And the second point I wish to make, though, is that I understand that the Sterling Lads case is being relied on because the PCRs say that it is addressing the same question, that these decisions are taken in a series. The underlying evidence is very similar in these cases, they say. It concerns very similar conduct. And so the tribunal, they say the value of Sterling Lads is that the very same questions determined by the Commission are the ones which the tribunal has to determine in assessing the strength of the case, which is, I suspect, why my Lord Green thought there was so much value in it, because it does appear to be addressing on its face the very same factual questions which the PCRs.
It's not the same. Different evidence, different chat room communications, different defendant, but not entire coterminology. They're not coterminous in time exactly, but it's evidence that an expert body applied an approach to find a violation, which is at least in part consistent with that of the class representatives.
But that reveals, if I may say so, the unfairness and the treacherous nature of this process, because if the rule is limited to situations where the questions are exactly the same, and if not exactly the same, then you can bring in this material for which we had no right of appeal or anything like it. A case which is not the same but very similar can be relied on and given weight in the evaluative findings of the tribunal in a certification case. And it would be a very dangerous distinction to say this rule, this important rule of fairness, applies only when the question is exactly the same, but not if it's very, very similar. And that's the concern. And that's our concern in having this case relied upon against us, because we say the rule that makes it inadmissible is an important rule, reflecting fairness in civil proceedings.
And in the Qualcomm case, it was the same defendant.
Yes, but my Lord, I think nothing, the rule, yes, the same defendant, but as far as I understand the rule in Hollington Newthorne, nothing turns on that.
Well, as my dad put it, I mean, you accept that the rule in Hollington is designed to prevent J2 from considering her or himself bound by J1.
Yeah, that's the main vice, but the rule
On
goes,
the same facts, same list, same dispute.
but the rule goes
You
further.
said it has to go further.
It does go further. And it goes further, as Ms. Bacon with characteristic clarity explained it in this judgment. And that reflects what the Court of Appeal said in March. But if you're against me on everything that I've said, and you do look at Sterling Lads, my short point is that when you look at paragraph 171, and even the evaluative findings, which I skipped through, you will not see a finding about the magnitude of harm or the degree of likelihood that the individual traders would increase their own profits. Still less evidence of market-wide harm. And that, I'm afraid, other long detour.
No,
It's
it's a very
entirely my
interesting
fault.
point, Mr.
I need to go back to,
We need to think very well. We haven't heard from anybody else on the topic, but
I'll go back to my,
something to get our teeth into.
We're looking forward to Mr. Jowell apparently argued that point.
well, he'll have the answer straight away.
Yes,
He's just keeping up his hand.
Or is no doubt.
So the next point that I had, and in fact, in some ways, we've been kind of teeing up to the main flaw in the adverse selection risk theory, which is that all the non-respondent banks would detect that small and persistent harm and isolate it from all the millions of other small harms and deviations in profit that occur on their books every day. And this is, again, a key question relating to plausibility, because the facts are not in dispute. There are 39 to 55 non-respondent banks, a large number of non-respondent banks. According to the PCR's evidence, every day we enter into about 1 million FX transactions worth approximately $2.2 trillion. There are hundreds, at least hundreds, of legitimate reasons why, second by second, a non-resident bank trader might suffer a particular loss on a particular trade, or less profit than he expected to make. It is completely implausible that the non-respondent banks would detect and isolate those small losses from all the other losses and profit deviations in this extremely noisy, to use the trading term, $1 trillion market, subject to all of the normal everyday information asymmetries that Mr. Knight referred to. It's a short point, but it's a really important
The
point.
essence of it, you say, just there's insufficient transparency for anybody else to be able to take account of increased spreads by the defendants, such that they could follow the suit.
That's part of the problem. It's even more extreme here when the market is so huge.
But that's the point.
Sorry,
That's the reason why it is insufficiently transparent, so that the non-defendants would have the ability to follow. You just simply say it is, as you put it, it's noisy and $1 trillion, so it's too fast, too noisy, too much information, you say.
Exactly, and these are small and persistent losses that the whole adverse selection risk theory is that the non-respondent banks will isolate these, detect them and isolate them from all the other things that are happening in losses and deviations from profit. Still less attribute these losses to asymmetry, information asymmetry. You saw repeatedly the experts, the PCR saying, oh, when they realise, oh, someone has better information than me, that's what's caused that loss. I must widen my spread. It's just completely unrealistic and implausible. And the next stage, and that I'll show you in the judgment where that's addressed. And the next stage, in theory, is also implausible. But faced with small and persistent losses in the market, which the non-respondent banks can then isolate from all the other losses and profit deviations in the ordinary run of business, they respond by widening their spreads in the customer-facing market. And I'm repeating a point I made earlier, that the theory is that they have to make up for their small losses, but we ask why on a market-wide basis. That would make them less competitive vis-a-vis the respondent banks, which were often in a significant minority in the market at the time. The tribunal made a finding about elastic demand, which you saw. And these are the same respondent banks who, according to the PCR's case, are widening their spreads uncompetitively. Surely, we say, it's more likely that the larger non-respondent banks would see this, if they saw it at all, and undercut them to gain precious order flow. But the tribunal's concern was how the PCR's case would be made out at trial. The core of the adverse selection risk theory concerns the perceptions and the decisions that the non-respondent banks will take, the losses that they will detect and isolate, even as averages, the fact that these non-respondent banks will attribute these small losses to information asymmetry, and then take, as a result of that causal connection, take decisions to widen spreads in a way they wouldn't otherwise have done. This can only be shown in our submission with internal non-respondent bank documents and probably evidence from them, because we're concerned here not only with trade movements, but with decisions, perceptions and decisions, possibly thousands of decisions that non-respondent banks are taking in this theory. And we even assume against the respondent banks that their own data shows wider spreads by my clients. That can't be extrapolated so as to prove that non-respondent banks widen spreads in the same way. We heard a lot about extrapolation. The question was put to my own friends, by Justice Snowden among others, that how can you show that the non-respondent banks isolate the trades and as a result widen their spreads? We said, well, we'll extrapolate. We'll see the non-respondent banks are widening their spreads, and we'll just say, well, the respondent banks are widening their spreads. We'll say, well, the non-respondent banks will be widening their spreads too. But that is assuming the very thing which they need to prove, that the non-respondent banks spotted the losses, thought, oh, that's happening because of some other reason from all the millions of other reasons we see, and that's widened the spreads as a result. So how will they do it? And in the mountains of paper in this case, the PCR's response is very, very thin indeed. And you heard two slightly different answers from O'Higgins and from Evans. It was a suggestion that from, I think, O'Higgins, well, maybe we can get third-party disclosure. We probably don't need it. Just pausing there, these are, in some cases, foreign banks. There are 35, what was that? I said 39 to 55 of them, non-respondent banks. It may well not be straightforward, to say the least, to get sufficient third-party disclosure from all of these banks in respect to these millions of trades, to the extent that the non-respondent bank data is necessary to work out what decisions they took, perceptions they had, and why they isolated these losses from other losses or profit deviations. It's really a question, as I said, of evidence. So what's required is that somehow we get tons of evidence from non-respondent banks in relation to this question of perception and isolation. Many of these banks may be foreign. The people who made the decisions have had the perception and alleged decisions may be abroad. The tribunal doesn't have jurisdiction to compel foreigners to produce evidence. The PCRs say nothing about this critical question to proving market-wide harm. This all was before the tribunal. And I was asked, well, you, Mr. Kennedy, didn't put any expert evidence in. For some of these points, we relied on the evidence that the PCRs themselves put in. Because you heard from Ms. Wakefield this morning, don't worry, we have a plan for getting third-party disclosure, data, from third-party sources. And that was addressed by Mr. Breeden, Professor Breeden, in his third report. And could I ask you to take that up, please? It's in the third, this third key documents bundle behind tab 52.
Sorry, can you give us the number again?
Sorry, volume 3 in the key documents. And it's tab 52, page 3163. I preface this by saying that all the data in the world is not going to help them in working out how individual decisions were made, isolating losses and detecting them and attributing them to information asymmetry, and then making decisions about widening spreads. That is a question of evidence. But to the extent that they're looking for data, Professor Breeden addresses this from paragraph 5.13, and he refers to what Mr. Ramirez said about commercially available data sets, which Ms. Wakefield referred to this morning, EBS, Reuters, CBOE, and CLS. And we see what Professor Breeden says about these. Top of page 3164, for EBS and Reuters, and I'll just give you the highlights. I'm sure when our friends reply, we can go back and take you to the rest. Just above the first hole punch, Professor Breeden says, this EBS dataset, the trades on these platforms are in no way representative of trades between customers and dealers and are not a good source to compare trades between cartel dealers and customers with trades between non-cartel dealers and customers. Between the hole punches, spreads in these platforms to be, I'd expect the spreads to be influenced by collusion from increased ASR. I'd also expect the harm per trade to differ from those of other trading methods and other market participants, such as voice trading with customers. Thus, differences in results. So voice trading of customers, which is at the heart of this infringement, you have the point that the decisions are about voice trading, not electronic trading. Thus, the results the differences in results based on this data, these data, and those based on respondent data are more likely to be due to differences in trading method and type of market participant than differences between cartel and non-cartel transactions. Although the data sets cannot be used to reliably compare cartel and non-cartel transactions, they could be useful in other ways. And then he goes on to CBOE, hotspot. He says, second line, this platform is used more by customers as opposed to dealers. It's highly specialized. And last line, not representative of the full range of trading methods and customer types that dealers would interact with. It may include a significant share of customer-to-customer trades. Although trading on this platform would likely have been influenced by collusion, I don't think it's representative of the full range of trades non-cartel dealers would have had with their customers. And it represents a very small share of trading over the cartel's period. And then CLS, this is a settlement database recording settlement details of trades of all different types. It's more representative of the range. However, 4 lines down, the commercially available version of the database aggregates order flow into 5-minute windows, and so cannot be used to identify individual trades or give a reliable estimate of the effective spreads at which those trades were executed. And then 5.14, there's other third-party data mentioned Mr. Ramirez. They've confirmed that's not available for sale for use in litigation. It could only be obtained by a third-party disclosure order. Therefore, at 5.15, he says, my analysis can be carried out without any access to third-party data if need be, but he might make limited use of some third-party data sets for some purposes. So it's completely theoretical. He's saying he doesn't need to look at non-respondent bank data, still less evidence.
Forgive me, but it's important also to read the last sentence of that paragraph.
To the extent that I require third-party data for the purpose of my analysis, it may be possible to obtain third-party disclosure. I said throughout that third-party disclosure from those organizations may be obtained, but what those databases contain, Professor Breeden has examined. Now, this was tested before the tribunal. The tribunal had all of this before it, and could I ask you to go to tab 73, to the cross-examination of, it's page 73, 4921, the cross-examination of Mr. Ramirez, 4921. Where Mr. Hoskins for the bank's King's Counsel is cross-examining Mr. Ramirez. And his point here is that this non-respondent data that Mr. Ramirez is referring to is anonymized. It's anonymized, so it means you can't include customer-specific factors in your regression analysis. And you see that from just second hole punch from line 20. Mr. Hoskins is talking about, he's quoting from Mr. Ramirez's report. He refers to the databases that he intends to use. And then over the page, Mr. Hoskins to Mr. Ramirez says, this is line 13, the anonymized, he's quoting Mr. Ramirez, the anonymized nature of these data sets precludes the inclusion of customer-related explanatory variables. That's the ingredient, some of the ingredients into the regression analysis. Mr. Hoskins was cross-examining on regression. My point is a different one. For these data sets, these ones don't have customer-related information. It's anonymized. And Mr. Hoskins says at line 19, so for your class B, that's the market-wide harm, you won't have explanatory variables for customer-specific factors. And that's correct, isn't it? And Mr. Ramirez says, yes. But he says 2 of those are anonymous, so no customer information is really being present or persistent in the market. Mr. Hoskins says, well, that's a problem with the data you have, because you accepted a few minutes ago that when you are dealing with trades which are not anonymized, you do need to take account of the customer-specific factors in the model. And I take you to this just to show the limitations, serious limitations in the data sets that we will take you to this morning. But that's, as I say, by the by, because data is not going to fix this, and third-party disclosure will not fix it either. What's required is detailed evidence from the non-respondent banks, and there is no suggestion as to how that's going to be obtained. Now, the final stage of this theory is just as implausible, assuming that the non-respondent banks widen their spreads as a result of this detected loss caused by this informational disadvantage. And I don't need them to, my point is good even if they don't need the informational disadvantage element. I say, forget about informational disadvantage, even expecting them to isolate, detect and isolate the losses, the small losses in this market is completely implausible. But the next stage is that assume the non-respondent banks widen their own spreads. The respondent banks will respond by widening their own spreads. But you saw, my lords, that on the PCR's case, the respondent banks, in theory, have loaded costs onto the non-respondent banks, which causes them to set uncompetitive spreads. By definition, the respondent banks do not face these costs and can more profitably tighten their spreads with a lower cost base. They can win the business with tighter spreads and gain valuable order flow. We made the point to the tribunal showing that is more plausible. Now, the tribunal heard contrary submissions from friends, but ultimately the tribunal found that we were right, that the arguments that at the end of this chain, the respondent banks would have widened spreads too, was part of the problem with the plausibility of the whole theory of adverse selection risk. And my point is that based on the evidence before them, it was open to them to make that finding, and it was not plainly wrong. And after that, my lords, I'd ask you to go to the judgment itself. Before going to it, my overriding point is that the focus of the tribunal was on the pleadings, but that was a shorthand for the tribunal's concern to understand how the PCRs proposed to have their case tried.
I think they do say that. They say that they haven't ignored the experts and so on.
Exactly.
So I think we take pleadings as a shorthand for all the evidence which was before them.
I'm grateful for that.
And that seems to be the approach they took.
Yeah.
Whether pleadings is the right word to use is another matter.
It's an unfortunate label in my submission, but that was what they plainly had in mind, was the methodology showing causation purely theoretical, or didn't have a basis on facts that could emerge at trial. And that's very close to the methodology concerns which this court addressed in Gutman and in McLaren. It has a real echo of the concern about methodology, which this court identified as a separate consideration in certification in McLaren and in Gutman. But I'll go to the judgment, if I may, and deal first with the standard.
In McLaren, we were concerned that the tribunal hadn't grappled at all. Here, the contrary is put that they grappled too much.
I'm sure the president would say they can't win, but that's the concern. My point here is that, and this is why it's important to show you the material, to see what they had before it, because it's tempting for this court to see fragments of the evidence and to take a view, but the tribunal had far more, and I'm trying to give you a flavour of what it had before it, when it made that multifactorial assessment, which ultimately it did. But now we're in the judgment, tab 14, and I want to address you first with a standard which was applied by the tribunal regarding strength. Because I remember Mr. Joel suggested at times that when the tribunal referred to American cyanamide, it's page 291, please. When the tribunal referred to American cyanamide and Four Seasons, oh, sorry, I'm told that it's 3:15. Sorry, at 3:15, you have to have a break. Thank you very much. We're not there yet. So when reference is made to American cyanamide and Four Seasons, it suggested that the standard which the tribunal had adopted was that the claim was likely to succeed. That's not what the tribunal found. All it said on the standard was what we see in paragraph 113 on page 291. And I draw your attention to the very last line on the page. Plausible, in relation to a statement or argument, means something reasonable or probable, and we consider this to be useful, and no more than that when considering the phrase strength of the claims. Plausible was the term they used, and just as a useful guide, there was no stricter standard was applied by them. And that's appropriate, we say, when considering the sliding scale of strength in applying the Rule 79.3 criteria. Now, with that in mind, we turn to page 325. And I'm conscious that you've been through much of this already, so I'm not going to go over a lot of your ground. 325, we have the articulation of the O'Higgins claim. You've seen it already, paragraph 188. And if you go over the page to page 327, again you see a reference in the O'Higgins pleadings to the global and vast nature of the FX market. It's the indented paragraph 10 on page 327. This is a reference to what you saw from Professor Breeden. But in fact, when you look at FX spot trading and OTC derivatives, it's on average $5.3 trillion per day. And then paragraph 190, a reference to the Breeden evidence, to my Lord Justice Green's point that the tribunal was not just looking at pleadings but at evidence also. And interestingly here at 8.4, Professor Breeden that's quoted, last line, again, the point is made about the knowledge of order flow being a key source of information and competitive advantage. 8.6 is the reference to adverse selection risk. 8.7, the non-respondent banks suffer losses. And interestingly here, the point that's made by Professor Breeden is 8.7. The non-respondent dealers find themselves at an information disadvantage. So they have to realize they're at an information disadvantage, and they tend to lose money on trades with the exclusive group on a greater proportion of customer trades than usual. So they're comparing it to some other situation where they weren't losing in this way. And then as a result of perceiving that, 8.8, they widen their spreads, disadvantaging their customers, and then the respondent banks copy them. It's just asserted. And then Evans, over the page, we have their claim form, paragraph 193. We can skim over this, you've seen it before. Ms. Wakefield took you to it. Then 194, 195. Each step, although it's set out, is just asserted. Bless you, my lord. And then 197, we have the pleading cases of market-wide harm heading. And here the tribunal is recognising its challenge. The importance of pleadings is to enable the parties and the court to know exactly where they stand so as to prepare for a fair trial efficiently. And if you go, please, then to paragraph 229, which is on page 358. The tribunal engages with the question of market-wide harm. Paragraph 231, they're engaging with the theory. There's no doubt that the experts have set out adverse selection risk as a matter of theory. And they say that at the bottom of 231, we have no difficulty as a matter of theory in postulating or accepting that information asymmetries in the FX markets, including but not limited to unlawful information asymmetries, might generate increased costs to large numbers of participants, resulting in increased spreads. But 232, this theory doesn't of itself constitute an arguable legal claim. It's just assertion. There's no particularity to make it triable. And particularity, again, maybe is an unfortunate word, but it's like, where is the meat on the bones? Economic theory doesn't automatically or easily translate into a legal claim. This is what a civil action requires. And they refer to actionable, the bottom of little 3, and identifiable harm caused by the defendants of the claimants. And they refer to the economic theory of these transmissions.
233, are they right in the way they identify the ingredients in an aggregate damages case?
232, my lord.
232, yes. Do you need identified or identifiable claimants? Do you need actual identifiable harm caused by the defendant to the claimants?
Actually, well, in terms of identifiable class members, yes, because that's part of the test for certification.
Okay,
Class
I'm just
members.
wondering actually if because causation may be different in an aggregate damages case to an individual case. The causative links have got to be tracked not only to the other side of the market but down into that individual. In an aggregate damages case, it may not be quite as extensive.
Possibly not, but the reference is to claimants, and the tribunal was concerned here with market-wide harm, and the tribunal was asking itself what needs to be shown, and the approach in the tribunal for collective proceedings is still compensatory. It's not necessary to show individual harm or individual loss to particular class members, but the principle is still that the class as a whole should be compensated. It's still necessary to identify harm to the class. So it's still, you still have to show that this class would suffer.
I understand that. I mean,
losses.
they're described as radically different in Merrick's and in Lloyd, but the extent of the causation exercise will differ. You've simply got to show that the loss is transferred over and then be able to quantify them, not that they transferred over and then trickle down to individual X and Y and Z.
But it's true that at the certification stage, one is looking at how strong a methodology needs to be to show ultimate harm to the class. The tribunal will take a broad brush approach. My concern here is not with that final stage. We're not at the stage of the individual class members. We're at the stage of the non-respondent banks, the prior critical stage in the chain of causation. How the tribunal is not dealing with it here, but that's my answer to my lord's point, that, and elsewhere we see the tribunal doing it. How can they show loss to the identifiable, discrete, isolated loss to the non-respondent banks, and then the non-respondent banks will widen their spreads as a result?
I mean, it's probably time to have a break very shortly, but speaking for myself at the moment, and maybe we'll come back to it after we do, or give me an answer straight away if we can, but looking at 232, in fact the end of 231 and 232, I'm not actually sure the account has really put this quite right. I mean, speaking for myself, I understand the economic theory, and the economic theory is appears to be properly explained, if you like, with sufficient particularity as a series of assertions. I understand entirely what the experts are saying. This is their economic theory, and they've explained it in step-by-step analysis. The question, as I understood it, the account was trying to maybe say was, it's all very well to have an economic theory. What you need to do is to translate it into a factual finding at the end of a trial, for which I'm not sure particularity is the right word at all. Evidence might be a better word. In other words, in order to render the claim triable in the sense of being arguable, you've got to have some evidential basis or some factual assertion which gives the court the belief that the economic theory that people are espousing actually was what happened in this case. I mean, is that...
I respectfully agree, except to add this gloss, that it's not enough simply to have a series of factual questions in the bare assertions. There has to be something that renders each of these stages plausible. Just no higher than that, plausible at this stage, because otherwise...
plausible because there's some possibility of a factual or evidential basis being established for the economic theory.
Yes, and that's...
But at that stage, you then come into the informational inequality that the CAT identifies in these types of cases, that at the start of the case, all the facts and all the evidence are, generally speaking, on one side of the fence and not known to the others.
But that problem of informational asymmetry between claimants and defendants isn't the problem with this application. That's not the problem here. The problem here is
I thought it was rather what you were going on about, if you don't mean that in any derogatory way, because you've been pointing, at least most recently, to the lack of likelihood that the claimants will be able to get the material they need from particular evidential sources. I thought that's exactly what you were doing.
No, I'm sorry, well then I wasn't being clear. That point is not about the data that we could have. It's about the evidence and the data from the non-respondents.
Okay, no, I understand. This is all about, this all, it's highlighted or most vividly addressed by reference to the non-cartel respondent, the traitor non-cartel respondent. I understand that entirely. But that's why you've been focusing on it and saying, we've got what we've got. But look, a massive chunk of their case is all about dealings between their class members and non-cartelists.
It's not just a massive chunk, it's the whole case on market-wide harm. It relies on showing the non-respondent banks.
Well, it's the whole case on market-wide harm, yes, their whole case is, I mean, their case contains two elements. One is dealing with cartelists, and the other one is dealings between class members and non-cartelists.
Well, it's market-wide harm that particularly concerned the tribunal, and it's the one that I've been addressing you on. And that's the deficiencies that I've been addressing will not be fixed by our data or our evidence.
That I understand.
I need to get to the. We will stop now because this is not the judgment where I say the tribunal was dealing with the concerns that I've been raising. When they say, my last point on this at 233 is when the tribunal says that this evidence has to somehow translate into a series of averments capable of being tried. I think that's the point which my Lord Justice Snowden was making to me, that really what they're feeling for is a series of factual questions upon which they have a plausible case that will show the tribunal that this can be tried properly. And we'll see that when we come later to the relevant bits of the judgment. So if I may, for the shorthand version, I'll stop there, and if that's convenient at the moment.
Okay. Are you saying what you want to?
I'm sorry, well, we were told that we need to have a break at 3:15.
Well, we had a 5-minute break previously, but due to me,
I'm sorry.
I'm very happy to take another one.
I know. I was told to offer it, so if I'm happy to carry on, I don't need the break.
Well, we'll take a break. 5 minutes.
All right.
Oh, right. Okay, so what's the answer?
That's when I last saw you. She's one of our friends. What is she? I already use the same
So I don't know what you guys are doing for the coverage documents, but my solicitors have spoken to or emailed with Roger Snowden. And we're going to speak at the end of the hearing about putting in big versions of like Ryan and Ramirez, putting their neutral statements and stuff. And we've got to look at using this for the social share. Yes.
So we've got the additional bit of
I think it was an architect. In general, they're reports architect.
No, also the anything there was the key but not full. Yeah.
So maybe when
We do want to fill out a few of the other tabs of the key.
okay, sure. So maybe what we'll do at the end then, one of us can just stand up and explain that we've got various bits we need to put in the bundles. Can we just stay behind at the end of the hearing? They leave their bundles, we'll stick stuff in, and the usher help to do it, pass up tabs, and then we can give our reading lists. Because I think, well, obviously we shouldn't look at judicial bundles when you understand they're saying, put this in this tab, that in that tab, otherwise if we hand them in pack of documents, it's just not going to work. Another wonderful point.
So we just give it to the usher.
Yeah, no, exactly, but we'll just coordinate that at the end, but ask them to leave their bundles behind. Maybe ideally what we do is just make sure that they've got them. And then in terms of time.
Oh, I see. So we put both.
Just need to say realistically we won't be able to sit early and sit later.
Certainly said early.
Yeah.
I don't think Friday's an inconvenience at all.
No.
We need to try and respect that we're talking.
Yeah.
Please don't make me come back on Friday. No, you too. Well, I'm labouring away. I'll know at the end of the house. I'll have a good idea at the end of this.
How long will you be tomorrow morning, do you think, Ryan? Do you have an idea?
Don't know, actually. It depends on the next.
I think I'll still have to come out.
I can make a load of progress now. At least an hour.
Gosh, okay. If we start at 10 then, and that's 10 to 11, what we try and do an hour-ish between us. And it might be okay.
Yes. They'll sit as a divisional court. No, it was
Did I say to you I'm having June, July and August off?
a half an hour
having
point on
sabbatical.
costs. The
3
sort of
months.
court
I know.
For you, sorry.
I know.
Separately, so it wasn't.
No, I'm counting down the days.
When you get back, you can tell me how you managed to.
When
When did you, how long ago did you start training?
A year.
So a year.
Yeah, this time last year. So obviously I basically had a few weeks where I didn't sleep. I then nearly left the bar. Tony Burgess, our class said they'd be sabbatical.
All right.
Thank you. So we're in the judgment. Now we're on page 362. Move forward, please, to 362. And the tribunal, at little two above the first whole bunch, repeats the point that market-wide harm can't be pleaded at the level of economic theory only. The matters that they refer to in paragraph 232 are unlikely to be provided with the specificity required to try a claim by theory alone. And I think that, in my submission, that goes to the question or the insight that Lord Snowden had before he broke. And they then go on to try and suggest how it might be done. And if you go over to page 363, Roman 2, and I'm looking at halfway down Roman 2, the tribunal gives us an insight into what they would like to see. And they refer to some particularization of how the cost of the illegitimate information imbalance found in the decisions manifests itself in the market. Now, there's a lot packed into that sentence, but it must, in my submission, include the point we were making at the tribunal about the non-respondent banks detecting and isolating the losses which were caused by the information asymmetry. And then the next
Where did the class get their quotes, specific examples from in the last but one line of it or two, if it's not from disclosure, in an asymmetrical information case? It might well involve extrapolation from specific examples. So they recognise it's very difficult, and on the previous page they say, well, we're open to novel ways of articulating claims. And one of those would be extrapolation from individual examples. And so really, where do they come from, if not disclosure?
Well, first of all, is the tribunal asking about the point I just made? Because there are two things that they would like to see. An analysis of how, and I'm paraphrasing, the non-respondent banks isolated and detected their losses. And then second stage, how the non-respondent banks then decided to widen their spreads downstream. And that's what the tribunal is referring to in little 2. And then they say it's difficult to explain that or to show how that, to show a plausible case on those points. But they say you could extrapolate from specific examples. The tribunal there may be referring to examples of how even in a very, very noisy market with a $1 trillion market with millions of exchanges with all the different noise.
What about trade witnesses, people who were dealing in both in whistleblowers who come across, we see happen from time to time, plus traders who had expertise in non-defendant banks who come and talk about how, give examples of what they knew or didn't know, and that's one form of evidence which one sometimes sees.
My Lord, yes, there's a prior point which is in this tightly packed sentence, which is the imbalance found in the decisions. I think the starting point of the tribunal is going back again and again to what was found in the decisions. So how do you show that these sporadic exchanges of information on bid-ask spreads and the more extensive and recurrent non-bid-ask spread information exchange, how do you show that they, which are occasional and between individuals, then manifest themselves in all the things I've been describing?
Yeah.
So I think the problem.
Well, you break it down there. You start off by saying Joe Bloggs spoke to Fred Smith, and that had an effect upon the trades that they were doing. you then have to ask yourself the question, did Joe Bloggs' activities have an effect upon the trades that other dealers at the same institution were making as well into the market, in other words, within the cartelists? And that's an evidential question which is going to be helped by disclosure, isn't it? Because you know, the employer of Joe Bloggs will have to give disclosure of what its other traders were doing, so that somebody will be able to do some form of analysis to see whether what the economic experts predict as to the effect of Joe Bloggs' activities within his own institution, whether that's made out. Now that's a part of this claim, undoubtedly, which will be assisted by disclosure from the cartelists, won't it?
Well,
Sorry, it's likely to be, and that's good enough.
I would say that point runs contrary to the Commission's findings, but the point, my lord, is I need to show the whole thing.
No, I'm not at all. I'm saying that the Commission's findings are that there were whatever the analysis was. The Commission didn't go on to say there were no effects upon other traders within the same institution. It's just it's an open question, isn't it?
Indeed, and as I said, the effects are up for grabs, and so one can
within
imagine
the institution.
yes.
So that disclosure from the institutions involved could well provide, or sorry, at this stage, there's at least a prospect might provide the claimants with sufficient evidential material to make good their economists' theories in relation to within the cartel.
Yes.
It's exactly the point that this court made in Gutman, which I was just looking at, paragraph 55, which deals with absence of disclosure.
Yes.
We said at the certification stage, all that might be possible is for the class representative to advance a methodology that's a plausible method, expert methodology, identifying what might be done following disclosure.
Yes. So that's why I said I mean, subject to my Commission decision point, I absolutely accept that, and that's why I was focusing I said the main problem is the non-respondent banks, because it doesn't depend.
Yeah, well,
on
I
disclosure.
said I was going to do it in stages.
Right.
I got sidetracked at stage 2, because stage 3 is where the focus may well be for everybody's debate, and indeed for the CAT's concerns, which you've been highlighting, which is how do you move from the cartelists, trades with the cartelists, which I think is the Evans category A, if I've got my class A, to the market, class B.
Yes.
And you say they haven't got a prayer where they're going to get this material from.
I say they haven't got a prayer because it's so inherently implausible, and where would they get the evidence from? But I have 2 points there. It's not just about.
Okay, but I've got the framework, conceptual framework right.
Yes. Subject to the Commission decision point.
Well, in terms of at least the battle lines, saying nothing about the answers, but that's the conceptual framework for the battle, isn't it?
Yes, because these 2 different stages, 2 main stages, which is what's happening within the respondent banks, and then, which is my main point, which is what happens even if even if all the respondent banks were coordinating in the way that's alleged. You have the point about their market shares. Could they be, is it plausible they could inflict these kinds of losses at all? And then, how could the non-respondent banks identify them?
We have a snowballing effect from individual traders, if my lord is right, in stage 2, which then affects the whole of the organisation. We've seen some of the evidence which might impact upon that. So let's assume, for the sake of argument, that there was complete tainting and the infection spread to the entirety of the organisation. Given the scale of these banks, we've got quite a substantial market share of operators who systemically will have affected spreads, 40 to 45%. And what's the impact of that on the market as a whole? Because a lot of your analysis has been this is trillions of transactions, a few sporadic transactions by individual traders. What happens if it is 5 major organisations systemically rigging the market across the board? Is that not likely to have a spin-off effect, or a higher probability of a spin-off effect?
It is a higher probability than if it's just the 4 or 5 traders in the Commission decision. Of course, I'd accept that. And everything I say is subject to the point I make about the strength of the case. its inherent plausibility reduces the more they contradict the Commission decision upon which they're based. But just assuming the structure has been put to me, plainly, yes, that even assuming, which is a huge stretch, that all the banks have been tainted and they're all tacitly coordinating, the market share is important, the point I made. It's 48% for 1 year.
Yeah.
Some of the time it's 20-something%, sometimes 30%. And the idea is that they are, and this bid-ask spread idea, looking at bid-ask spreads alone, all coordinating to widen their spreads, offering worse prices in the market. True it is that for a particular client in a particular trade, if it happens to be taking quotes from the two conspirators, that client may well suffer and be offered a worse price. But that's a million miles from showing that as a result of these banks offering less competitive spreads in the market, Deutsche Bank with 20% market share will say, oh, we should also offer a higher price, instead of coming in and saying, we'll have all those clients, thank you very much, and the ton of order flow information that comes with them. And internally, one can imagine the non-respondent banks saying how efficient and clever we are that we're in the market winning these trades against these wide spreads that our rivals are offering. It's just much more, that's a plausibility question. And that's even before you get to the adverse selection risk problem, which is these decisions which the non-respondent banks are taking internally, even if they suffered small and persistent losses as the claims.
You made a very cogent case identifying why, particularly on the market-wide damages claim, the battle might be bloody. And you may actually make very many good points as to why the damages might be vastly overblown. To what extent, though, is that something which the CAT was really capable of expressing a view about, absent disclosure, absent expert reports? Or should it have said, we should draw stumps now, we wait and see what happens, because we always have the safeguard in 6 months' time of coming back and striking it out. It's not as if it's a once and for all for the CAT. And one gets the impression that they felt that it was once and for all. They couldn't just draw stumps and say, there's enough, notwithstanding our doubts, because we have this rear guard or this protection later on if we need it.
As I'll show you in the judgment itself, in my submission, the tribunal had amassed a ton of information. In fact, probably more in terms of actually weighing all the stuff they had. You had a flavour from my own friends, the successive pleadings, the circulating submissions from which we get comments, 8 stowaways full of papers. The tribunal had a huge amount of information, including detailed rounds of expert evidence from the PCRs. In my submission, rather than taking the course which my Lord, Justice Green, has put to me, they said we have enough material to say now, at the certification stage, this case is really...
Because that's exactly what they didn't do.
Well,
They said, we're not going to strike it.
No, I'm focusing only on the strength factor under Rule
The
793.
point that's made against you is they shouldn't have gone down that road, having said they weren't going to strike out, for the reasons they gave, because it was effectively unfair to do so. They should have drawn the line.
And did that footnote say they haven't formed any view on the merits?
Well,
No,
I'm
I mean,
looking at
for
this-
all the 8 stowaway boxes, I'm sure you're right, that is, one shudders, frankly. This is supposed to be an interlocutory process. And I know endless appellate judges have said for God knows how many years, all these interlocutory matters should be dealt with in 5 minutes in the privacy of your room and all that sort of business. But the reality is, the idea that there was this amount of material, and that one's only got to the certification stage is quite worrying in a way, I think.
Yes, indeed. Well, more worrying if every single one of these cases ends up in the Court of Appeal as well.
Well,
with all the same volume of material.
Yes, of
And I'll come back to
Yes.
the multifactorial assessment when I
point
conclude.
taken.
But my Lord,
We haven't even had disclosure.
no. But the point is that in this process, the tribunal did have a huge amount of expert evidence from the PCRs and material before it. And in my submission, it was entitled to say, in looking at the strength, that we think their case is extremely implausible, and that is a strength factor which tends towards opt-in, not opt-out. Now, I don't need to defend their decision on it's amenable to be struck out, but we're not going to strike it out. All I need to show is that there was a proper basis. They weren't plainly wrong in saying this was very, very weak, and that was properly a factor in their strength assessment for the purposes of Rule 79.3.
what does the CAT do is if it finds that part of the case is stronger than another part of the case, such that part of the case, if alone, might be suitable for opt-out, but there's another part which, on your argument, say, is very, very weak, which, if it was the only case, might not be suitable for opt-out, on your argument. Could the CAT not say, look, opt-out is the appropriate vehicle for this case, and if you don't, you, the defendants, don't like the very weak part, you can strike it out. Apply to strike. If you think it's that bad, strike it out, but it doesn't mean that you make the whole of the case opt-in.
The problem with that approach is the tribunal has to form its own view. It's required to form its own view on whether it's opt-in or opt-out. And one of the factors it's invited to consider is the strength of the case. So,
well, that's the point my law's putting to you, really. That if you end up in a situation where, I think the point my lord has in mind is Class A is strong, much stronger than Class B, putting it that way. And the CAT forms a view for the strength of Class A is such that opt-out's the appropriate approach, but Class B is much, much weaker. So if it stood in isolation, you'd say opt-in. But if you've decided that Class A is opt-out, and Evans persists in having the two classes, then surely the right approach for the CAT is to say, well, this has got to be opt-out. And if you, the defendants, don't like Class B, you can always apply to strike it out.
I mean, that's how you cure the unfairness or the oppression, all the points you took us to in the pre-legislative material, in talking about the problems and unfairness to defendants faced with these opt-out claims. If you think that there's a part of the claim which is so weak it's unsuitable as an opt-out claim, it should be excised, but the onus is on you to excise it, not to make a decision on opt-in or opt-out on the basis of the weakest bit of the case.
Again, two answers, if I may. The first is, if that were the right approach, then what does Rule 79.3 add? Because it's always open to a respondent to apply to strike at any point. But Rule 79.3 is there as an additional safeguard which the tribunal must exercise.
I think in the government's response it was put the other way around. I think, but if you tell me the reference to it again, it was put the other way around. It wasn't it?
Oh, yes.
Give me the reference to the...
Yeah, 52 and 53, is it?
Sorry, which one?
It was the legislative material that you took us to.
Sure, there were three different ones.
The last one.
Volume 6. The tribunal rules consultation behind tab.
I hope I'm not about to be proved wrong.
57. 57.
Was it the one before? Hang on. There was paragraphs, I think, from memory, something like 316, 316. Is that the ones? Yeah, 316, 317. Yeah, strikeout is said to be if you're 317, strikeout is a further safeguard.
Yes, and in my respectful submission, I would adopt that, because before strikeout is a further safeguard. It's always there, but it's further to the safeguard where the tribunal examines the strength of opt-in, opt-out.
But in my type of case, the balance you strike is I'm not now talking about this case, let me make it very clear, let me just hypothesise. CAT takes the view, there's a good strong case on part of this, the rest of it is pretty flimsy, but we're not quite clear at this interim stage of making a certification decision about just how good or bad it is. Let's assume we haven't been deluged by information. So you certify case on an opt-out basis, and then effectively the safeguard for the defendants is to say, okay, but that bit that's really weak actually should be struck out. And so we're not facing an enormous juggernaut, we're facing a focused opt-out case which has legs.
Subject to the respondents actually applying to strike this out, or
Yeah.
So that's a matter for the
of course,
respondents.
and
That's the
it's-
safeguard, that's the,
I understand that that of course is open to the tribunal. It has jurisdiction to go down that road. The problem with it though is that it rather ducks the job the tribunal has to do in the first instance, which is to assess the strength of the whole of the case. If the tribunal takes the view that this bit is good, but this bit is really very, very weak, in our view, regardless of what the respondents think of it, the proper approach is to certify opt-out, but only in respect of the bit that they think is plausible. And the tribunal is able to carve up the application to say, we believe this bit can be opt-out and this bit can be opt-in. They can say the class for opt-outs we will cap in some way by reference to turnover. We can limit the class members.
you can have hybrid, I wasn't aware you could have hybrid proceedings which are part opt-in, part opt-out.
What's the authority for that proposition?
Sorry,
It doesn't seem
It was
to be
in
the way
the
rules-
consultation.
I don't think you can, because I think, isn't that?
I think at least one of your juniors looking quizzical at that
That means I'm wrong.
proposition.
I think the point is that you would certify opt-out for a more limited group, and I suppose the rest who are not in the class could do something else. Perhaps that's I'll be told what the proper position is, but what's very clear is that
I think you better wait on this.
Well, I think my lord and I are a bit surprised by the proposition you could have both. You may be right, but
well, I think that the point I'm trying to make is that if it's definitely open to the tribunal to say this bit of the application is strong enough to be opt-out, and so we will certify that. Well, it is not what was sought by the applicants, but not this case, but by reference to the class members or the duration or aspects of the case. It can be they can say we will certify opt-out in this way. That will potentially excise class members or elements of the case. It is then open for I presume, unless I'm told otherwise, open to those other people who are now not within the opt-out class, if they're willing to do so, if they have the PCR and the organisation to do something else, which in theory could be opt-in. That's where I was coming from. That's the point.
But
But
the
the point is the
alternative-
tribunal can carve it up.
The alternative for the CAT though, just as a matter of process, is to say, look, we have to make a certification decision. That's the first step to see whether there's any proceedings on the road at all. We can see undoubtedly there's a bit of this proceedings which pass all the relevant tests and should result in an opt-out. Great. There is a bit which looks dodgy. We shouldn't here and now, in the middle of a certification hearing, get sidetracked down that line. We'll certify as opt-out, and if you, the respondents, think, in fact, it's so dodgy it should be struck out, that's a separate application which you make, and we can then focus on that particular point. And then we've got two sensible sort of slices at this.
And it would be, it's perfectly open to the tribunal to do that if they want to. But the point I would make to them, if that was put to us at the hearing, the point we made to the tribunal was, you don't need to wait for that application. You could decide now, based on what you're seeing about the inherent implausibility of this, to refuse to certify
Their
or
inherent,
part.
their inherent implausibility, whether it's as a matter of economic theory or as a matter of just how on earth did these blokes in the chat room convert themselves into market effectors on such a wide basis. That's really the area which I think, from reading the judgment, they're the most sceptical about.
So they could have said, we'll certify opt-out for Evans Class A, for the direct harm, for people who are trading directly with respondent banks. We would still say there's a big problem with that, because that's not just people trading with the actual traders. That's everyone trading with everyone.
But at least the evidence there, for reasons we explored about 10 minutes ago,
Yes.
might well come on disclosure from your side of the fence, because at least you're talking about what happens within your own institutions.
Exactly. And so for all the points that I could make, but I won't bother you with now, to say that's still very weak. But the point is, it's stronger, one could say in theory, than the much bigger, wider market harm bit, and the tribunal could have done that. The tribunal could have said, we'll certify opt-out for this. I'm not saying it would have been the right decision, we would have, but it was open to them to say that. The system allows them a great deal of flexibility once they certify. My point is that under 79.3, it's really, there's nothing wrong with them doing it. Parliament has told them to think about opt-in, opt-out, and to think about factors like strength, if necessary of its own volition, in making this important decision as part of the safeguards. That's in addition to the striker power. Sorry, may I go back to the judgment?
Yeah, sorry.
Thank you.
I'm taking you right out of it.
Not at all. I mean, I'm just sorry that I'm going over. I may need some time tomorrow, and we can address that when we come to the end of our agenda today. So now we're back in the judgment, and it's page 3. I'm taking you to 363 and that breakdown that we see there. Then 36. So now it's the O'Higgins claim form. We've seen this pleading already. I'll skip over it. 365. We see paragraph 13, and this is a reference to the O'Higgins theory of harm submissions. This is the detailed pleading on causation which the tribunal invited the PCRs to produce. So this is the O'Higgins one. So this is what we see there. Some of their final words on this question, on these causation questions that trouble the tribunal. And 365, we see a reference to paragraph 13 of the O'Higgins theory of harm submission. We see what they plead at adverse selection risk, and they say indented 1. A trader is likely unaware of the specific occasions when they trade with a better informed counterparty, but would experience greater average trading losses than would otherwise be the case. Skipping down 3 lines, they have to assume that every transaction in that series carries the risk that the counterparty is unusually well informed. Again, this is the idea that somehow they will isolate losses and attribute them to the fact that their rivals are unusually well informed. And that's raising rivals' costs. You see that at the bottom of that indented section. And then over the page, they explain, they make their points about widening spreads. Our submission to the tribunal is that it's all there, but it's still all theory and inherently unlikely for the reasons that I've already explained to you. Then we see this, sorry, just before we leave that, in little 3, on page 366, they do acknowledge the fact that the Commission decisions, you see this about halfway down little 3 on page 366, not Roman 3, the little 3 at the bottom. They refer to the Commission decision referring to tightening or widening the spread. But they say it's inherently more likely to have more often led to widening. So they just say, well, we disagree, and that's a point we made about the inherent implausibility. They just put to one side the fact that the Commission decision found both widening and tightening. And then we're now on page...
Sorry, wait a minute.
Sorry.
Sub 3 at page 366, that's just talking about intra-cartelists.
Yes.
So I thought you were making a point about the effect on spreads for non-cartelists. I think what your argument is, your point is it's implausible to think that all the other non-cartelist dealers would also widen their spreads. The little bit halfway down sub 3 is dealing with within the cartelists.
Oh, I'm sorry, I've skipped ahead. So the non-respondent dealers widening the spreads is the previous page, 365.
Sorry, which you said 366.
I'm so sorry. So if you go back to 365.
Sorry.
Sorry, I was going too quickly. Paragraph 13 we looked at, that is the non-respondent banks isolating their loss-making trades because of better informed counterparties. Then little Roman 2, paragraph 14 of the theory of harm submissions, that means that the non-respondent dealers widen their spreads.
Sorry, okay.
And then next paragraph, then the respondent banks,
Yeah.
having loaded those costs onto the non-respondent banks, and caused them to widen spreads, instead of undercutting them, apparently we then increase our own prices, even though we don't face the same costs, subject to the theoretical matters that are set out there. And then, just to move on, we go to the tribunal's analysis on page 367. That's Romans 3 at the bottom of that page. And I'm focusing here on the non-respondent traders. They suffer loss through information asymmetry. That's not an allegation that the entire market suffered a loss. It's specific to the non-respondent traders. The legal translation of that theory involves an assertion that a specific class of person, through their unlawful conduct, caused loss to the non-respondent traders. Now that can plausibly be asserted as a matter of economic theory, that in general, information asymmetry will result in an increase in the cost to the market. But the tribunal says a legal claim has to assert with some specificity that a given infringement caused a loss to the claimant class, the whole class, to my Lord Sweet's point. And this is the point I've been banging on about to paraphrase my Lord. The market will be redolent with information asymmetries, many of them entirely unlawful, and the pleading has to identify the losses caused by the illegitimate information asymmetries. And that's the point about detection and isolation. And then what needs to be pleaded is that the infringements cause some identifiable loss to the claimant class. Now, my friend Mr. Joel said, oh, that means quantifiable loss. How can we quantify it? But that's not what the tribunal was complaining about. They were asking, you have to show how these infringements in the decision cause this identifiable, isolated, detectable loss to the claimants via the non-respondent dealers. And it's not enough simply to say that there was an increased cost because of the reduction of competition, because of information asymmetry. That has to be identified. It has to be identified. It says in the pleading, I would say, also in the evidence. And the essence of the claim the tribunal summarise, having reviewed all of this material, is that the actions of the respondents reduced the efficiency of the interdealer market, and that was a weakening of competition. And the inefficiency meant it was passed on because of widening of spreads. And they say, in theory, that could work, but it's not identified. Now, the word identified is used repeatedly, and in my submission, that is a shorthand for what I've been describing. The fact that the individual steps are not being separated, and there are critical issues in relation to this question of detection and isolation by the non-respondent banks and their decisions to widen spreads. And the tribunal goes on then, the bottom of 368, how does the increased cost of doing business incurred by the FX market participants manifest itself? So how do these isolated detected losses appear? How can that be separated from all the other costs, legitimate and illegitimate, that will be incurred? Now, they're not saying here, because you will be incurring millions of losses and profit deviations in $1 trillion market every day. That has to be what they have in mind, because that was the evidence before them, and that's what they're getting at here in my submission. It's not enough simply to say, I've incurred costs and you caused it. And they say then at little 5, echoing my Lord Lytton's agreement in Stellantis, that the pleading is just theoretical. It just assumes the pivotal links. It sets them out, we don't deny it, but they're just all assumed. And this is the case as regards the very first of these pivotal links, namely the very existence of the loss to the non-respondent dealers. And they're focusing there on the key flaw in the PCR's case. And then they get to the next stage, they call it passing on, but they mean the widening of spreads by the non-respondent dealers. And again, they ask, how is that going to be shown? Because that depends on competition between the non-respondent dealers and everyone else. That's the point I made, that surely it's more plausible. Well, even if they isolated these losses, why would they widen their spreads? That's, again, in a highly elastic market like this. And these are findings of fact that have been made by intramarket competition in this judgment. And then over the page 370, about 5 lines down, even if the cost is passed on in the form of increased spreads, how is it passed on? How, even if you assume an identifiable and unlawful cost, incurred by the non-respondent banks and other traders, then on what basis can it be said, sorry, I think here they're not the non-respondent banks, but the FX market participants, how is the loss caused to them? So a little 10, they say, third stage, with the response of follow the widened spreads. Again, it turns on the extent to which they non-respondent dealers could increase their own spreads. That's little 10. It's entirely theory driven. And they don't, and over the page, they say, well, this isn't going to be fixed by disclosure. They don't specify which bits will not be fixed by disclosure, but you have my submission that all the issues relating to the non-respondent banks will not be fixed by data or disclosure from the respondent banks. And just hoping something will come up is the wing and a prayer, which is deprecated nomura. And they say regression analysis. This is little 7. Having heard the evidence that the experts cross-examined by Mr. Hoskins, and he cross-examined them on regression analysis, they say we're not confident that that will demonstrate the kind of correlation between the infringements and the movements in the market. That's again condensing a lot between the decision and movements in the market by widening spreads. But the regression is not going to fix that. That's because of the multitude of other factors that may affect the level of spreads in the FX market, which is hard to control for. Now, that's a focus on regression, but there's a prior problem, which is the one the tribunal identified, which is how can you show that the non-respondent banks identified the losses, isolated them, and made decisions about them.
Can I just ask, what do they mean in the last sentence of paragraph 238? So I assume you've got to the last sentence of 238.
I have. This is if there's an arguable statistical case on causation, it should be pleaded first with disclosure following.
How do you plead a statistical case before disclosure?
It would have to be some form of model.
Yeah, so it's not what do they mean by arguable statistical case?
That would, well, that's because they're asking about all the other factors that affect levels of spreads. And
do they mean arguable economic case or what?
They must mean arguable for the purpose of strikeout, because that's what they're considering.
But you can't plead statistics by definition until you've got disclosure of the raw material. You can't say what the numbers are.
But they could plead by cross-referencing economic evidence, some form of model, which would say this is how, because the concern the tribunal has is how is regression analysis going to deal with the correlation between the infringement of the decision and the ultimate widening or narrowing of spreads. Yeah. And the problem was that the tribunal heard the evidence on this and had real doubts about whether the regression analysis was plausible, because, not least because, as you saw, the data that
they don't mean statistical, do they? Did they mean some sort of, you've got to plead a case about how you're going to do it?
Exactly. It can't be,
you can't plead the numbers.
You can't plead the numbers. You can't plead the numbers. You can't plead anything like the numbers.
So, okay.
It has to be a proposal for a model, which will, when the numbers are plugged in, deal with all these variables. But the point is a good one.
Or at least saying this is where we're going to get
because
material from.
Exactly, because what the regression analysis will do is try and isolate the effect of the harm. And the problem is that in this case, there are thousands of variables which affect the harm. And Mr. Hoskins identified from the experts that for some of for many situations, it wouldn't be possible. There was no, the experts themselves accepted that they couldn't get individualized information. And there was, I'm not going to debate the evidence on the regression analysis, but plainly it was put to the tribunal, it was argued at length, and the tribunal said, we are not convinced that it's going to be good enough to fix the problems we've identified. And then we have the evidence claim form. We have Class A, and then Class B. I'm just skipping ahead.
I'm sorry, just so I fully understand that. When in the last sentence of 238, the tribunal says, if there is an arguable statistical case on causation, and they say it, you're not actually saying that there has to be the statistical case.
No.
But really it is methodology pertaining to.
Yes.
Yeah.
Yes.
This is the plausible methodology.
Exactly.
Not quite what they say, but.
No, but I'm submitting to you that's what they meant.
Yes.
Now we're on page evidence, Class A and Class B, it's been explained to you. And I'm looking at paragraph 392 to Roman 2. That is on page 373. Sorry, 373 is where it starts. Sorry, 374 is where Roman 2 is. And they say, dealing here with Class B, so this is the market-wide harm. The assertion that one consequence of the infringement was to enable the proposed defendants to unlawfully widen the spreads in the market generally is insufficiently justified in the face of the claim form. And then this, it's not clearly evident from their case, it's not just the pleading, but the evidence, how a widening of bid-ask spread in the face of the prevailing market rate could be sustained unless either the market in question was uncompetitive or there was a market-wide cost affecting all spreads. And that's the point I've been making, that the tribunal had the market share information. The PCR's experts themselves acknowledged that the market was relatively unconcentrated, that there was competition, and it was a fungible good in a highly liquid market. And the tribunal struggled to understand how could they sustain wide spreads when 73% of the market is competitive. And then we look at 2411 on page 376.
Why did they say at the end of sub-Roman 1 that the distinction between Class A and Class B becomes much harder to understand? I don't understand why what they say means that Class A and Class B had become one.
My Lord, I asked myself the same question. May I come back to you on that tomorrow? My learner juniors will help me, but I don't have an answer for you.
Yeah, okay.
Off the top of my head.
I mean, I'm puzzled by that as well.
My submission is it doesn't.
With respect to the tribunal.
My submission is it makes no difference to the.
Well, I follow that.
But I also,
Make any difference, but-
I'm sure somebody will give me a very clear, cogent answer, which I will be grateful to pass on to you.
Yeah.
Then the conclusions. I see the time.
Yes. How are you doing?
I have about an hour, maybe a little, yeah, about an hour left, which means I'm coming in well short of the time taken by my friends in opening.
No. Well, let's not have a battle of who took how long. We probably interrupted more than any of you thought, so
I doubt it. We were anticipating the interruptions.
The difficulty is tomorrow, of course, we then need to reply, and then we have the entirety of the carriage appeal, and then the very short cost JR, so 20 minutes or so. So there is an awful lot to fit in tomorrow.
10 o'clock. It's 10 o'clock.
10 o'clock.
I'm happy to start again at 10.
Can you start at 10?
Sure.
Yeah. Yes, quite. Well, is 10 o'clock going to be convenient for everybody? Sometimes it's not just you. Actually, I'm sure it's convenient for the silks, but you've got big teams, and we've had issues about court dictating that we'll start at 9 o'clock, and then they discover that nobody can be there at 9 o'clock, and they want to rearrange their lives, which we don't want to happen. So if we say 10 o'clock, we probably sit 10.
I'm getting nods from my side, my lords, from everyone on my side, that 10 o'clock tomorrow is fine for us.
10 o'clock tomorrow is fine. We'll start at 10. That's okay. We start at 10.
I think Mr. Joel had something
There
to
is
say.
just one other thing, which is that the costs JR, 2 points on that. One is that the Mr. Shail Patel, who's the costs leader, will only be here on Thursday. He can be here on Thursday, so he can. Forgive me. That problem is gone. But there is also, I mean, I think it is going to be challenging to fit everything into tomorrow, even with a 10 o'clock start. I mean, one possibility would be to say that the costs issue should be heard on another occasion, because it is contingent on the two appeals. So if it only arises if both of the appeals fail. So it could be said that
we'll rise for a minute, possibly 2 minutes, and just discuss this, so don't go away.
No.
Because the real issue is whether we dribble
All
on
right.
Friday, I think.
Yeah. Coordinate lapse, which is really good, isn't it? It's very absolutely. We just don't. It's not good. I mean, obviously, it's a waste of time. You just don't take it's like enough. I think they might say that there isn't progress. I'm doing all-day interviews on Saturday for pupillage, so 15 of them. I'm chair, so I haven't read it. It's an hour series, which is that I have to run 57 and a half hours. Well, McSorley says that he's identified the concept. He's saying it's going to involve numerics. So he's doing that, and Richard Eshbeck is writing critical questions. So there is like customers. But honestly,
Yes.
thank you very much.
Well, considering that having to wade through this, I'm surprised at that.
That's right, that's right. About all the
What we could have done is a really rubbish version.
Sounds like they're very keen not to sit on Friday.
They are, but I think
All right.
Okay, plan B as opposed to class B. We will sit at 10 with a view to seeking to finish everything tomorrow. We could probably sit till 4:30 if we had to, so that gives you a bit more time. If we don't get to if it appears by lunchtime, let us say, that we're just not going to get to costs, but we can finish everything else, then we suggest that the costs issue is deferred, because it's a permission application anyway, I think. And it so happens that we are sitting together in the week of, well, it's the Tuesday, the 9th of May. Certainly for 2 to 3 days, and we could probably slot it in then if we absolutely had to.
I'm grateful, thank you.
You told us it's only going to be a minute.
Just 1 minute, 30 seconds. I'll do it very quickly, I'll do it now. There's one other issue which relates to pre-reading for carriage tomorrow, which my Lord Lord Justice Snowden asked about. We have both prepared slightly separate reading lists, but there's no great conflict between the two. And there are various documents which I think most happily could be inserted into your Lordship's key documents bundle. So for my part, there's full rhymes, full Ramirez's and so on, and similar I think for my learned friends. So Sorry.
Full breathing.
Full breathing. And so I believe that there's been communication between Housefeld at least and your clerk, who suggested that we might put these in your bundles at the end of the hearing, perhaps, assisted by the usher.
The end of the hearing tonight.
Tonight. I don't know
By all means, why don't you do that?
if we
I've got
could
limited
do
time to read in. I can't do anything on this tonight, and I've also got a meeting at 8:30. And if we're going to start at 10, I've got really limited
not much
opportunities
time.
to do much reading. So
Speaking for myself, what's the realistic time estimate for reading?
An hour, perhaps.
No,
An hour,
it's
my lord.
Probably an hour on our side. I mean, I'm very conscious that I have not taken you through this question properly of the non-respondent, the non-cartelist bank data, and I do need to. It is important. But I think that there is something of a misapprehension about
It's
the.
worth doing it
the
at
other
the
thing
time,
I was
so,
going to
yeah.
say on behalf of the entire court is that we will do our very best to keep quiet. But I hope that the interventions we've made have been, well, maybe not helpful, but they've probably
Very
helped us. And I'm always conscious that council sometimes think the court's doing far too much talking. I'm not trying to, by any stretch, saying you can go into Friday if necessary, but ultimately, if we had to, absolutely had to, we could sit Friday morning.
Thank you, madam.
Summer
That's very
Friday. But don't take that as permission to dribble on into Friday, come what may. Okay. Right.
Do you want
We
us to
hand
take-
up the reading list of this.
We don't have a printed out reading list, but perhaps we might send our reading list to you electronically,
Send
my
it
lord,
to us,
and
send it to us.
electronically, and then we can put the hard copies in your bundles now.
That's fine. All right. Okay, 10 o'clock tomorrow morning. I'm just going to get this